Are you buying properties subject to in 2026? Well, you need to rethink your strategy because it's about to get a lot more complicated for you now with the new federal reporting requirements that are going into effect on March 1st of 2026. In this video, I'm going to be breaking down for you what you need to do to structure your subject to transactions so you can work around this federal reporting requirement. Because I'll tell you what, you don't want to run afoul of this, because if you do, you can be looking at up to $278,000 in fines per transactions and sometimes up to 5 years in jail. All right, let's get started. Okay, let's talk about what we're doing with a standard subject to deal. You're probably doing this right now, and I'm going to then share with you what you need to be doing going forwards. So in most situations, when you're buying property subject to, we have a seller over here that's distressed and they're trying to get out of their property and you're offering them a solution. And so I know a lot of people who invest subject to, they'll set up an LLC, they have their limited liability company, and then what they're going to do is they're going to talk to this seller here and discuss, hey, I'm going to take this deal over from you, right? I know you've got a mortgage on it. We're going to keep that mortgage in place. I'm going to make sure that that mortgage stays current. I'm going to pay you some money. You're going to move out of the property, and then you're going to turn around and rent that property out and make some money off it, or maybe you flip it. Doesn't matter. But when you're buying subject to, a lot of times the way these deals are getting structured, or they have been, and this is where the problem comes in, is that you enter into a purchase and sale agreement with the seller with your business entity itself. Now, some savvy investors who have been doing it for a while know to do this. Let's say the LLC is, name of this LLC is RE LLC. So what they'll put on the agreement is RE LLC and or designated entity. Now, why do I say they use this? Hopefully you're not using and or signs. It's so that you have the ability then, if you wanted to transfer it to another entity at closing, to do that. So you're not required to close in this LLC itself. In fact, that's how I like to structure my offers, is because I never know where I'm going to close. Or maybe you just close in the LLC and then you move it later. But the fact of the matter is, there's a problem with this type of deal structuring here when you're entering into a subject to transaction with your limited liability company. What are those problems? Well, the first problem is always going to be the due on sale. Now, many of you are probably aware of this, that when you transfer title, that is when the seller transfers title to this property into your LLC, that if the bank discovers that transfer, then they could accelerate the note. Now, a lot of times in the past, for the past 15 years, this hasn't been an issue. Interest rates have been down. Banks haven't been looking at taking back properties. They don't want to deal with that. But now we've transitioned the last year and a half, 2 years, into an interest rate environment where there's a financial incentive. Let's assume that this seller here is sitting on a 4% mortgage, right? Well, a bank knows that if it finds out about this transfer, it could call the note due and force someone else to step in to buy this house and finance it at 8%. So they can double their interest. So the banks have a lot of incentive then to start calling these notes due if they find out about the transfer. So here's the risk you run, in my opinion. When you're transferring these properties into the LLCs now and thinking, oh, I'm fine, I'm not going to alert the lender, I'm not making any mistakes like I've heard in the past where people contact the lender and now have the mortgage statement sent to an out-of-state address, or they screw up the insurance policy so the bank finds out about it because the insured gets changed on it. Another problem. If you're not doing that, have you considered that banks now have been reading about are putting in place AI to go out and start searching records and looking for have there been any transfers from the borrower to a third party? You see, AI is helping a lot of people. It helps real estate investors find deals, but it's also helping banks identify problems in their own portfolio of loans to determine whether or not a borrower is still on title to that property. Now, I don't envision this being a problem with a Freddie or Fannie deal, that when that property or that mortgage has been sold off, I just don't see them doing this. And this is something, if I was buying a property subject to, I would probably look at the very outset. I'd want to know what type of financing institution I am dealing with here. And so the way you discover that is when you're talking to the seller. Okay, you would discuss with the seller, you need to get the seller to go onto the internet, bring your computer and say, hey, listen, let's go to Fannie Loan Lookup Tool. Look this one up, Fannie Loan Lookup Tool. And then do the same thing with Freddie. So first go to Fannie, you'll go to a website and have the seller put in all their information for that property, their name, social security number, that property address, and you'll find out whether or not Fannie owns it. Do the same thing with Freddie to see if either one of those institutions hold that mortgage now. The reason why I like to do that, or I tell people to do that, is because now I think you're in safer ground, okay? It's when they don't own it and you have the lender that's still holding on to that note, they think you have more risk in these transactions. So you have to be ultra conservative and careful you don't trigger that. Because I've dealt with clients who've triggered it accidentally, and the lender, because it wasn't held by Freddie or Fannie, have actually called the note due on them. And it's been accelerating. I've seen more and more of these in the last year because people have been screwing up and alerting the bank somehow, some way that the property's been transferred. So that's the first problem. Now, the second problem with this transaction is something that no one's been talking about now. And for many of you, this is probably the first time you're hearing about this if you're not following my channel. And that is, there are new reporting requirements that go into effect on March 1st of 2026. Now, what does that mean? Okay, this new reporting requirements. Well, FinCEN has implemented new regulations that state that whenever there is a property transfer not subject to a mortgage that has been issued by a lending institution that is subject to anti-money laundering rules, you got to give information to the federal government. When I say give information to the federal government, here's what you need to do. You need to report on yourself that you bought this property. So you have to collect certain information from the seller because you have to report information on them, and you have to report information on yourself. So if I bought it with my LLC, not only do I give it my LLC's information, I also give it my personal information because I am a member in that LLC. So that means a copy of my driver's license or passport, my personal address. Okay, all that needs to be submitted. Now, what is the government doing? They're tying property transfers back to you personally. So even if you're using a business entity and you're buying, say, 3 deals a year, within 10 years, they're going to know every deal you've ever purchased, and they've tracked them all. Now, I personally don't feel comfortable with that, and I don't want them to know that, so we need a workaround. Now, this workaround starts with how you structure this deal at the very beginning. Otherwise, you're going to be forced to do this. And as I stated earlier, if you get it wrong and you don't report and you're caught, that's $278,000 per failure to report if it's intentional. And I personally would not want to give the seller that type of leverage over me, because if I was a seller and I wanted to extract more money out of you later on down the road, I felt like, oh, you shortchanged me. That's one way to do it. Hey, either pay me or I'm going to report you if you didn't file, okay, to FinCEN. Now, if you didn't file, you'd be a little nervous because you have a certain window, 30 days in which to get that filing in. So how do we protect ourselves? Well, we protect ourselves and kind of solve the due on sale clause with the same tool, the way you set the structure up. So if you're going to buy property subject to, then what I suggest you do is you create a land trust here. Okay, so we're going to create a land trust to purchase this property from the seller up here. Now, what's unique about this new structure that I'm rolling out for you, compared to what I used to talk about with putting these deals together, the way we would structure them is we'd create a land trust, and this land trust would be owned by an LLC down here, and then our client, or maybe generally a Wyoming LLC, would own this red box. Now, why did we structure it this way? Because the land trust is going to buy the property. It's going to take title of the property. And when the property goes into the land trust, we don't want this individual, our investor client, being the beneficiary of the land trust, because if they are, and something were to happen with somebody on that property, they sue the trust and then they sue the individual investor, because the land trust, with the exception of Florida, does not offer asset protection. So if something were to happen with one of our tenants, they sue the trust, and then they name me personally if I'm the beneficiary. Or on the other side, let's say I'm driving a car, looking at properties, and I'm involved in a car accident. I get sued personally. If I'm a beneficiary of a land trust, they take my land trust from me. So you got two areas there in which you could lose your deal. So the way we solve for this problem, is we make your LLC the beneficiary of the trust. So if anything happens here, then that liability comes to the LLC and I'm protected. And vice versa, if you've set it up with a Wyoming holding company down here, okay, so we take you out and we use a Wyoming LLC like this, then you're protected from that car accident. Your property is then protected. Okay, so that's last year's way of doing things. This year, it's changed. Okay, we're not doing this anymore because this creates a problem for us. It will trigger the FinCEN reporting. If this seller, okay, up here, is not the beneficiary of the trust down here, then you're going to have to report. So what do we need to do now with these types of transactions so that I avoid having to report? Well, here's how you should structure your deals now. You set up a trust. You make the seller the beneficiary. No longer are you going to make your LLC. The beneficiary equals seller. Now, the trustee should also equal seller. All right, you want the seller in both positions, trustee and beneficiary. Here's why. Okay, number one, we talked about the due on sale clause, and I went through that with you. Well, the way you can give yourself a ton of protection here, if a lender does look, is to make it appear as if the seller set up their own trust, maybe for estate planning reasons. That's what the assumption is always going to be. So when you create the trust and you come up with any name you want for this trust, let's call it the Alpine Trust. Okay, I put the seller's name down as the trustee. Alpine Trust, care of John as trustee. Okay, so when I do that, when I set this up, if a lender on the property were to look at title, or their AI system goes out there, they'll say, yeah, John used to own the property in his own name, but then he's transferred it into a trust. Now, here's what's so cool about this, is the trust is a private document. So the AI cannot research and pull up the trust document to see that John's no longer involved, as I'm about to explain to you, in this trust. Because unlike an LLC, there's nothing that has to be filed anywhere. Okay, so you set it up as follows. John is the trustee. Now, you put in here the successor trustee. That is the person or entity that steps in when John is no longer able to serve as the trustee. So the successor trustee is either going to be you individually, or if you're using a Wyoming limited liability company to serve as your trustees. And if you go down that route, then you just use one Wyoming LLC to be all your trustees, and that is the only thing it should do, nothing else. But let's just say we're using you now as that successor trustee. So you put yourself down as the successor trustee. So we have done, by setting it up this way, and then we have John deed the property into the trust. So he deeds it to the Alpine Trust. John is trustee. Now we've checked two boxes and solved for two problems. The first, due on sale, right? Bank acceleration. The second is the new federal reporting requirement. Because as I was telling you earlier, that kicks in when it transfers to an LLC. It also kicks in if they transfers to you individually. It does not kick in if it's transferred from an individual to a trust where it's a grantor trust in which they are the beneficiary. So in this case, look what we did. We had the seller transfer property into his own trust, meaning a trust where he's the beneficiary. Now, how do you then get this deal and take it from the seller? Okay, so at this point, you're no longer buying the property. So most of you in 2025, 2024, if you've been doing subject to deals, you've always been buying the real estate from the seller. Now what you're doing is you're buying the beneficial interest of the trust from the seller. not the property itself. You buy the trust owns the property, you get the property that way. This is how we're now structuring these deals, because when you transfer the beneficial interest, because what you're doing is you're buying the beneficial interest. So now I have my LLC right here. I'm going to buy, the LLC will purchase this beneficial interest from the seller. So the seller now will assign it. Okay, the seller is going to assign the interest. So that is a piece of paper. It's called an assignment of beneficial interest. They'll assign the interest over to your LLC. That is the sale. You're buying the trust from the seller. Now here's what happens. When that gets transferred over to your LLC, private, no one knows about this. Okay, banks don't know about this. The second benefit here is that nothing has to be reported to FinCEN. You see, with that new reporting rule, it's only on that initial transfer. There's nothing in the rule that requires that when we transfer a trust to another party, that we have to report on the individuals involved in that transaction. So this is a workaround to the reporting requirement. So now we're going to move the trust over to the LLC. So now the seller is no longer the beneficiary. The LLC is the beneficiary. Of course, when we do that, we no longer want the seller to be the trustee. So we have the seller resign as trustee. When the seller resigns, you become the trustee, because in the document itself, it states that you are the successor trustee. So you step into control when the seller resigns. Now, if you're doing this type of transaction like I just described, and this is how I would set all my deals up in 2026. In fact, I've told any real estate investor, 2026 is a year of land trust if you want to avoid federal reporting. So in structuring this deal, there's a couple other documents you should be aware of that you need to have ready for the seller to execute to protect you on this transaction. Okay, so what are those documents? Okay, so those documents are as follows. Number one, what you want to have is a trustee's deed. Okay, so what is a trustee's deed? That is a deed from the seller to you, where the seller as the trustee deeds you the property, okay, as a new trustee. So a trustee's deed essentially transfers the trusteeship from the seller to you, because when that seller resigns, you want to have this document that if you need to record it to have your name appear on title, all you have to do is go down the county recorder and record it, and then you pop up. I've executed easily over 40,000, if not more, of these trustees' deeds in my career, because I have served as a nominee trustee on a lot of land trusts, of course. And then when I resign and my client steps in as the trustee, because they're listed as the successor trustee in the trust document, then I give them a trustee's deed. So if they need to put themselves on title so they show up rather than me, they just record it, because I've already resigned, I'm out. So I would get a trustee's deed. Now, the second thing that I would get is a limited power of attorney. Now, this document is important because what it gives you the ability to do, that is, the seller appoints you a limited power of attorney to make decisions about the property. So you're controlling the property. So third parties work with you, because the problem you run into on using a land trust on a subject to deal, the way I've just described, is that the seller's name, again, is listed on title as that trustee, because you're keeping that ambiguity there for the bank so they don't see what's going on behind the scenes. But that also can be a double-edged sword. You get the benefit there, but it can cut you on the other side when you're trying to transact business with this trust. So you have to have that limited power of attorney to make sure that you can control the property. Because even though you're the trustee of the trust, the only way you're going to fix that is by recording the trustee's deed. And you don't want to do that, because then that blows your anonymity and it lets the bank know that, you know, someone else is involved. Now, the third thing that you need here, you should ask for, is a third party release. Okay, release to third party to release information. Now, this is for your lender or for the seller's lender. Now, this document right here, okay, this is a break the glass in case of emergency document. You're gonna put it in your file. You're not going to do anything with it. The seller's gonna sign it, give it to you at closing, but you're not gonna reach out to the lender. This is how you can communicate with the lender if you need to regarding that mortgage. Now, this is what has triggered a lot of lenders to accelerate mortgages on properties that have been transferred to buyers via subject to, because they're getting used to seeing this now and they know, probably the property was probably transferred. So this can become a problem for you, but you still need it in case you have to get involved with that lender. Then in order for them to deal with you, you have to have that on, I would have that from the seller. And then the final document I would prepare, of course, is and have on file, signed by the seller, is a seller's disclosure of risks. Okay, now this document right here, when we put these together, what it basically states is it lists out that, hey, the seller understands what they're doing, that they're selling this property to you, that they still remain obligated on the mortgage, that you're going to make the payments for that. I also now are putting in there the FinCEN reporting requirements. I understand it would be subject to FinCEN, but now it's not. That you're going to be, that they plan to resign as the trustee. They're no longer going to be in control. And we'll also put in there what they agree to sign. And so they understand the risk and what they agree to do. I bury all that in that one document, have them sign it. And the reason why I've been doing this is because when you close on a deal like this, there's always that risk. And I've seen this come up, where if the seller runs into financial distress, or even worse yet, say the worst happens to you, you do this deal, you really didn't appreciate the risk that's involved in it, and something goes wrong and you have to walk away. And so then the bank forecloses. Well, they're going after the seller, all right, if there's a deficiency judgment, and the seller could turn around and come back after you saying, I didn't understand what was going on. Or the seller tries to buy a new house and they don't qualify because they have this mortgage on there, and then they go after you saying, you and your not paying off this mortgage and leaving them on has caused them a financial hardship, and now you're liable. I've seen that happen. People, our clients that have dealt with these deals, they didn't set it up the right way, and then they came to us with these problems, say, hey, I'm being sued for this. Seller disclosure of risk, I think, is critical in putting together these types of transactions. Listen, if you're going to go out there and you're going to do a subject to deal, the fact of the matter is there's still great deals to do, but I just think you need to paper them better here in 2026 to avoid some of that new federal regulations and avoid the banks coming after your deals. Hey, at the end of the day, it's more paper you get on these transactions, the better protected you're going to be. And I just want to say this, I wish you the very best with your investing. And if you like this video, hit the like button. If you have any questions, put them down there in the comments below. I respond to all the questions that people leave on my YouTube channel. Take care.